Well, hello. If you've made it this far, congratulations. We are in Unit 4, Area of Study 2 of Legal Studies, which is the last area of study we need to cover before your Year 12 Legal Studies course is completed. This last topic relates to court processes and procedures and engaging in justice. Now you'll see here, this is straight out of the study design, and at this point in the year, if you haven't got the study design, please make sure that you download it. It is a really great checklist for you on what you need to know about the course. I'll just read this section out quickly. Court processes and procedures and engaging in justice. Dispute resolution through courts operating under the adversary system of trial is characterized by formal processes and procedures that must be adhered to by all parties involved with the case. Students investigate the major features of the adversary system of trial and, aided by a comparison with the inquisitorial system of trial, evaluate the adversarial approach to dispute resolution. They also examine criminal and civil pre-trial and post-trial procedures. Students investigating the role of criminal and civil juries consider their strengths and weaknesses and suggest reforms and alternatives applicable to the current jury system. Throughout the investigation of court processes and procedures, students assess the extent to which these processes contribute to an effective legal system. So there is a lot of content there, and this is a very large area of study. It's worth 60 of the 100 marks allocated to this unit in the course. And so don't be overwhelmed. At this point in the course, you should be familiar that we work through the study design very carefully. Outcome 2, which relates to this area of study. On completion of this unit, the student should be able to explain the processes and procedures for the resolution of criminal cases and civil disputes, and evaluate the operation and application, and evaluate the effectiveness of the legal system. So you'll see that word evaluate is coming up again and again, and the skills that you've developed so far in using the right language and the right weighing up of different factors, using that hand gesture again, will come into play again. Very quickly, we're going to divide how we look at these sections in the study design according to an effective legal system, what that means. We'll then look at the adversary system. You'll see again strengths and weaknesses come up again, and we'll be using the exact same process to deal with essay questions on that topic. We look at the inquisitorial system of trial, which is something you're probably not familiar with at all, and we make a lot of assumptions about how we run our justice system in Australia and in the Western world, things that you're familiar with in television. But there are other places in the world that do things very differently from the way that we do it. We look at criminal procedures, something that you may have covered before in Year 11 legal studies, things like bail and pre-trial procedures. But we're going into a lot more detail. We'll be looking at committal hearings and what they're used for. Again, we look again in Year 12 at criminal sanctions, and you did a lot of that stuff in Year 11. You may remember the acronym PPDDR, which we use to remember the purposes of criminal sanctions. But we again have to delve in a lot deeper and look at the types of sanctions and the specific purpose of each of those types of sanctions. So more than just saying jail or a fine, you're going to need to be able to talk a little bit more about why they're designed that way. It goes on though, we then, after having covered criminal procedures, we look at civil procedures as well. And you'll look at things like pleadings, discovery and directions hearings. Again, those things we would have covered very briefly in Year 11. We need to go into a lot more detail this time. So don't rely on the knowledge that you already have, and be prepared to really supercharge the detail that you have in your toolkit. Juries, again, we know what they are. We're going to look at in detail the things that influence how they're made up. Strengths and weaknesses, that comes up again. And then we start looking at reforms and alternatives. Again, the final part of this area of study will be very much focused on looking at, well, here's the legal system as it is at the moment. What can we do in the future, and what is already being done to make that a better system? And you'll see there at the bottom there, recent changes and recommendations for changing the legal system designed to enhance its effective operation. Skills are as per every other area of study. A real big focus on using legal terminology, being able to apply it to case studies, and then further down, being able to evaluate strengths and weaknesses and discuss in detail the sort of reforms and alternatives to the existing system that we have, which might be better. And again, that word evaluate comes up again.